Greetings to all the viewing audience. We are having fun with public officials today, as usual, holding them accountable for their dereliction of duty. They have a duty to know, and they have an obligation to perform. And we were in the federal court today with the federal clerk of the Southern District of Indiana. Now, we didn't actually get to talk to the clerk of the court today. However, there stemmed a bit of a controversy for which we're eager to provide remedy as honorable men. We are not steadfast to steam off to war. No, just merely provide a little correction. We have five more cases started. All right, same format, ladies and gentlemen. All right, nothing new, but there is a total of 5. I'm not going to read them all. In fact, I'm not going to read any of them because I'm not. So, but in order to get this, you should have seen the circus I had to jump through today. First, I had to start off by reading the Indiana State Constitution. Then they tried to get us to fill out a complaint form. We are men. We're not here to complain. We're here to make claim. Completely separate jurisdiction. Now, I don't know if this gal was put in the woodworks to thwart our authority or to misguide or misdirect us. She alleged to be the clerk of the court's legal advisor. If that's the clerk of the court's legal advisor, the clerk of the court's going to be in big trouble. Because that woman was, a few short sticks from being competent, okay? So, we handled our affairs. We had to read the Constitution to him twice before finally they were just like, give the man what he's asking for. I mean, he who denies principles, there is no dispute, and engaging in extortion is highly frowned upon. But we have an issue with what the deputy clerk of the court did. You see, she converted our claim in the jurisdiction of the Commonwealth of Indiana, the Republic of Indiana, which is guaranteed to all of us, the common law, and she converted it into a civil matter without our authority and without seeking the administration or the proper judicial officer to make such a determination. So we have a federal clerk of the court who at one point did the right thing and gave us a miscellaneous filing number, which is where we wanted to be. This is not civil and this is not criminal. This is a miscellaneous filing for a harm caused by way of trespass, caused by way of property, okay? Now, today we found out who the magistrate is going to be, which is great. We're going to send her on Monday some information about the rules of the Wilder Court and how this court is going to move forward. The rules are very simple. Nobody's going to argue with them, but they just need to be upheld. And in order to uphold these rules, they need to be supplanted into the case file jacket and they need to be affirmed, okay? We're the ones that do that. We're not using their paperwork. We don't belong to their legal society. I am not an employee of the federal government. The federal rules of civil procedure do not apply to I, like the clerk of the court or deputy clerk of court would like to believe they do. Okay. And she was trying to sway me into believing into her beliefs, which were a bunch of cockamamie horsepucky, especially when it got down to the fact of reading the Constitution to her and her still wanting to be derelict in her duty. Finally, somebody with some sense came forward and said, look, give them what they want. By the time we left today, we were surrounded by about 9 U.S. federal marshals. Of course, they didn't put their hands on us. They're not intervening. They're just civil standbys, making sure nobody's being threatened. I am the most professional you will ever see me in a federal courthouse because these people are charged with the duty of upholding our rights. So naturally, I have the Constitution before me. I have the Indiana's Constitution, the federal Constitution. There's no qualms about why I'm there. And if you need me to give you your directive, I will gladly read it from the book that you swore an oath to. So with that said, I'm about to show you guys how powerful this is. All right. The proof's in the pudding. Was it $420 per case file they wanted? And there's 5 of them. So do the math. Okay. Not a penny paid for. Nada. Because there is no such thing as what they're asking for. Because why? They won't quantify specifically what they're looking for. So they're only doing that to see if you're an incompetent. They're testing your grit. Greetings, Hattie Harmon. Oh, yes. I man, known to use the name. Derek Staton. Family with Gonzalez. Write this friendly correspondence to assist you in this glorious journey we call life, granted to us by the Heavenly Father, for which I am charged with the duty of being an ambassador of peace and a brother in Christ, doing the good works of the divine Creator. With that said, I send this to you in good faith, with good conscience, and for good reason. 1. The clerk of the court is a ministerial position not having authority of a tribunal, and therefore the clerk of the court is required to carry out the ministerial duties of a clerk. The ministerial duties of a clerk does not allow the office of the court clerk to act as a tribunal and make legal conclusions resulting in the dismissal of court motion and petition before reaching the court. Hattie, you do not have the ability. You are not competent enough, okay, to make legal determinations about how I press a claim. And you exhibited that with your behavior today. And that's a reason that you're an assistant deputy clerk of the court and you are not a judicial officer charged with the duties of being learned in property law, okay, and how it's to be upheld and enforced. That is why you are just a clerk of the court or deputy clerk of the court, and you are not a Supreme Court justice or a federal court justice or even a lower county court justice, although you may pass for a county court justice the way that they screw people over all day. You're probably knowledgeable enough to do that, but you're by far not competent enough yet to be a federal court judge for the state of Indiana. And that is exactly why you're in the position that you are, probably making about $60,000 to $90,000 a year versus making upwards of $500,000 a year being a judicial officer of the court, expert in property law, going by the nomenclature honorable judge. I'm going to help you out a little bit more just so you don't get in trouble in the future. Please do not take this as me ostracizing you, merely trying to help you out so in the future, the great American people that come to you, you will execute your duties faithfully, post haste, without delay. 2, under the Federal Rules of Evidence 201D, this court and its clerk's office must take judicial notice of a adjudicated fact by the Supreme Court in Matthews versus Eldridge, 424 U.S. 319, 1976. And why I am mentioning that is because Hale versus Hinkle is very clear that justice shall be administered without delay and without payment, or it will be considered and perceived to be a denial of due process of law, extortion under the color of a law, oppression under the color of authority, because you, my dear, do not have that power, okay? Abracadabra, poof, let it be gone from your head. You don't have it. You don't possess it. Where the fundamental requirements of due process is the opportunity for the movement to be heard at a meaningful time and in a meaningful manner inside a courtroom before a judicial officer. Now, we were at the Southern District of Indiana's Supreme Court Clerk's Office, which is not a courtroom, although I can hold a court right there if I choose to. Again, you are outside the scope of your authority by altering the intent of this document, which is a trespass by you, trespassing against the claim of this man that's coming forward, okay? By making legal determinations that this was civil, absconding from the fact that we know the intent and the reason the claim is being filed. And it is not a civil, at-law claim dealing with some whack-a-mole in his ens legis capacity. This is a claim being pressed by a man against another man, so as we don't cause harm, damage, or loss to the public sector, the U.S. taxpayers, and your insurance companies, okay? We know what we're doing and we know why we're doing it, okay? Because it's time to hold you guys personally liable. Screw the insurance. We don't want to ding the insurance companies anymore. We want to go after your personal assets, because that may be the only way you ever learn. See, if your insurance premiums go up by 60, 80, maybe even $1,000 a month, who really gives a shit about that? You don't. It's just a premium. Big fucking deal. What's the likelihood in your career that another man will figure this out? However, if we hit you personally in that pocketbook, ooh-wee, that's going to hurt, all right? We know that that's how you people are going to learn. We know that. So let me continue on. Opportunity for the movant to be heard at a meaningful time. That time is not there in the clerk of the court's office, where we are simply there to get a docket number. That is not the time to hash things out, even though you went to law school and you may have passed the bar, but maybe you don't have a bar card at this point, because as I read the Indiana state decree on assistant staff or attorney assistant staff for the clerk of the court, they merely passed the bar exam. It doesn't necessarily mean that they are a bar carrying member. So you may not even be considered an attorney at this point. You may just be a glorified assistant of an attorney, all right? Maybe you're a paralegal. Opportunity for the movant to be heard at a meaningful time in a meaningful manner. In a meaningful manner is not there with a bunch of U.S. Marshals standing around us like somehow we're criminals. That is not a meaningful time. It is not a meaningful manner. Inside a courtroom before a judicial officer, we most certainly were not before a qualified judicial officer today. The undersigned is filing court pleadings, which includes legal arguments that are supported by adjudicated facts. Now, granted, we weren't filing pleadings and we are not filing motions, okay? This is a claim being pressed by a man, and you don't have the ability to tell him how, what, when, where, and why to file it, period, unless you want to accept the liability of the other man or woman that the claim is being pressed against. You can aid and embed them if you like, but then you become a liable party to the claim. And we would really like to not have to make you a party to this action. And you wouldn't be a party because that would be the legal side of things. You would now be a woman causing I, a man, harm by trespass on my claim, or the claim of I, which is the property of I, which boils down to the right of I to a redress of grievance, okay, to remove controversy and provide remedy for what I believe to be a trespass against I. See the difference? Legal and lawful. Completely different jurisdictions. And I will forgive you and extend some grace to you, because I know that your mind has been polluted and perverted by the legal society. And your training has led you to believe that you are superior to every incompetent imp that's out there that thinks they know the law. That may be true and probably better of 90% of the cases, but today, unfortunately for you, it is not. The undersigned is filing court pleadings in which includes legal arguments. There is no legal argument here. We have administered a private administrative process, and we are about to commence the enforcement of the claim, period. That are supported by adjudicated facts. Well, adjudicated facts would be like Hale versus Hinkle, okay? That was an adjudicated fact, stare decisis. The undersigned may be introducing evidence with the court pleadings, and thereby refusal to accept a docket pleading is consistent with obstruction of evidence and obstruction with due process of law. Now, That's pretty serious. Obstruction of due process of law is, in fact, ladies and gentlemen, obstruction of justice, which means the liability now shifts onto her for being derelict in her duty, and it's oppression under color of authority because she thinks she has the right to alter this man's said claim, and in fact, she does not. Okay? Now, again, we're not trying to be malicious or assholes about this, just trying to help them out, and my commentary is meant to be funny. I really am not trying to ostracize her or make her feel as though she's unworthy of her pay or unjustly enriching herself under false pretenses that she actually knows her job, okay? Thereby, this clerk's office and its employees' refusal to accept and docket court pleadings will be involved in violating the secured rights and privileges of the undersigned. Now, first of all, if the undersigned has privileges, he is in the wrong venue. The privileges only extend to corporations, entities, ens ligas, persons, things of that nature. As a man, we have secured unalienable rights, and our rights to redress a grievance, remove controversy, and provide remedy are our unalienable rights as a man to press our claim before a competent court of competent jurisdiction, all while filing due process of law, which does not include federal rules of civil procedure. But we'll get to that in just a moment. Hang tight. Of the undersigned. And this document will serve as proof in the future proceedings for damages that this clerk's office was given the opportunity to correct its action but refused to accept and file the paperwork brought by the undersigned. Okay, let me explain this to you. They didn't necessarily refuse. By the time we left, they did do their job. The problem is the deputy clerk of the court altered it. And you see this little thing up here that says CV, that stands for civil, and it really should say MS or MC, miscellaneous, okay, because we are not in their jurisdiction. And we made it perfectly clear that we are not in the jurisdiction of the United States, its territories, its subsidiary corporations, or its municipalities. You are grossly making an error at law, which is obstruction of justice. And we advised them to please refrain from making legal determinations. If there is such a legal determination that needs to be made, it will be made before a competent member of the court. Period. Not a assistant clerk of the court. Let's go on further. For damages, that this clerk's office was given the opportunity to correct its actions but refused to accept and file the paperwork brought by the undersigned. Even though they filed it, they altered it. And that in itself is an issue. They are not qualified to make those kind of legal determinations. And again, that decision should have been made before a competent member of the judiciary, before a judicial officer. Under full faith and credit clause of Article 4, Section 1, of the U.S. Constitution, this court must honor judgments by courts within the territories of the United States of America, especially the highest court of the land, the Supreme Court of the United States. Number 5, the clerk's office must accept possession and file pleadings regardless of local rules and thereby cannot refuse to accept possession under the claim of local rules. When you were telling me that I have to comply with the federal rules of civil procedure, all while absconding from showing me how the federal rules of civil procedures apply to I as a man, not as an employee of the government, which I have never been employed by the government, you were derelict in your duty and making legal determinations. Now, you proclaim to be a lawyer. I've since called the Indiana State Bar. They have not provided me a bar card yet. I have gotten online to see if you are a bar card carrying member, part of the legal society. I have yet to see any evidence of that. I would love to see the fact that you are a bar card carrying member. It would please me greatly to know that I wasn't that you weren't trying to give legal advice without being a bar card carrying member, which means that would have been the unauthorized practice of law. Not that I need legal advice, because I really don't need legal advice, okay? Legal is the undoing of God's law, where I would much rather be in the lawful side of things. God's law, natural law. The standard for the clerk's office to accept possession and file pleadings can be found under the United States versus Lombardo, 241 U.S. 73, 76, 77, 36 SCT 508, 60 LED 897, 1916. Number 6. The provisions of the Federal Rules of Civil Procedures concerning filing supplements follow the Lombardo approach. The provisions of the Federal Rules of Civil Procedures concerning filing supplement rather than alter the Lombardo approach. The clerk shall not refuse to accept for filing any paper presented for the purpose solely because it is not presented in proper form as required by these rules of any local rules or practices. Stone Street Capital Inc. versus McDonald's Corp. 300 F Superior 2D 345 District Court, D. Maryland. The clerk of the court, like a recorder, is required to accept pleadings and then file them. Period. Not make legal determinations about the way they're structured. The Federal Rules of Civil Procedure was the agreed upon format for the court proceedings. A paper is filed upon delivering it and the clerk accepting delivery. Federal Rules FPRC 5D2. The job of the clerk of the court is to file pleadings and other documents, maintain the court's files, and inform litigants of the entry of the court orders. Saunders versus Department of Corrections, 815 F Superior Court, 1148, H49 ND 3, 1993, Williams versus Panonsky. The duty of the clerk is to make his record correctly, represent the proceedings in the case. Wetmore versus Carrick. Failing to file documents presented and reflected the documents on the docket is a failure to perform the ministerial duties of the clerk of the court. It doesn't say to alter them to your liking. It says failing to file documents presented and reflected the documents on the docket is failure to perform the ministerial duties of the clerk of the court. The Indiana Constitution states in Article 1, Section 12, and I had to read this to them, so far be it from me to explain the law to anybody, but I don't have a problem reading out loud, Bill of Rights. Section 12, courts open, remedy by due course of law, administration of justice, all courts shall be open, and every person for injury done to him in his person, property, or reputation shall have remedy by due course of law. Justice shall be administered freely and without purchase, completely and without denial, speedily and without delay. This was amended November 6, 1984. Attempting to charge a fee in the interest of justice to remove controversy to provide remedy is extortion and or barratry. I require the law to be produced for the following: the finding of facts and the conclusion of law, if you believe the answer is yes to any of the following. Is there a law that states there is nowhere in the United States of America for a man or a woman not fluent in legalese or a member of your society to move a claim or invoke their right to a trial by jury? Number 2. Is there a law that states a man or woman have to belong to or hire a member of the legal society to move a claim? Number 3. Is there a law that states that the man or woman provides justification and or excuse for the robbery or theft of another man's property that said robber, man or woman, is not required to remedy in the spoken form in open court what moves them to remove said property or hire a lawyer to explain this on their behalf? Number 4. Is there a law that states that the court clerk does not have to provide their oath of office or bond, and that they have the right to determine law or deny man's or woman's claim, and that any man has the right to process their claim via public venue for the use of any man or woman requiring justice and the immediate release of their property? Number 5. Do the Federal Rules of Civil Procedure apply to I, a man, Derek? Number 6. What is the difference between lawful and legal? Number 7. Does the clerk of the court have the power to alter the property of I, in this instance, the claim of Wilder? Now, it's obviously not my claim. However, I was there to witness it. So these are the series of questions that she got served. Now, we will see what she does with it. Why is this not opening all the way? Okay, so Federal Rules of Civil Procedure, Rule 17 says the capacity of the plaintiff and defendant is public officer. All right, so Federal Rules of Civil Procedure apply to who? Well, Rule 17 in the Federal Rules of Civil Procedure says that it applies to public officers. It's a reflection of Article 1, Section 8, Clause 14, and Article 3, Section 2 and 3. Recognize that those are the only two articles for the type of courts they have in their jurisdiction. Now, we're not operating in their jurisdiction, and we thank you very much, Malika, for helping us out in this instance with that great bit of knowledge that you have provided under the circumstances, and we thank you very much. So with that said, ladies and gentlemen, don't take flack from anybody. Be accountable, be responsible, be polite, be dignified, and you can get this stuff done too. Now, we have the docket numbers. I will just merely amend them because she trespassed on the claim. We want to offer her forgiveness for her ignorance and operating in haste. There's an old maxim of law that says, he who pays with haste pays twice. All right. So instead of making a hasty legal determination, you probably should have walked upstairs and said, Your Honor, I need to talk to you real quick. There's a peculiar man down there that he seems to think he knows something, and he's telling me that I can't alter this man's claim. Is there any merit to that? Well, what's the man say? He says he would like it filed miscellaneously, not civilly or criminally, because that falls within the territorial jurisdiction of the United States, and he's clearly operating in the Republic. Yeah, give that man what he wants. You see, but instead, you operated with haste, wanting to be right, having be-rightitis, and you stamped this civil, which altered this man's claim, and tried to bring it back into the jurisdiction of the United States, Title 28, 3002-15A, and its subsidiary corporations, and that is not what the intent of this man's claim is, period. So with that said, I love you guys. Anybody do the math on that? Five times 400, and I think it's 402 or $420. Pretty good chunk of change that we saved today, just knowing the law of the land. And with that said, for you students, participating members who took the class, it is 12 hours, 54 minutes, and 13 seconds long. It is finally uploaded to Mega. I'm just sitting here putting the rest of it in there. You guys will have it this evening. Okay, be looking for an email from Derek S. Gonzalez if you're a participating member in the class or you've since sent a donation for the copy of the class. It was Beat the Vaccination, okay, or Beat Vaccinations. With that said, I got to get to work. Love you guys. Thanks again, Malika. You're a rock star. We'll talk to you soon.